What's up, everybody? How are you doing? This is your brother Sylvester Moore Eel from thctrust.org. And this video is about land patents. Land patents are said to be the superior form of title in the United States. And to some extent, I think that is true within the United States. So from my understanding, and none of this is legal advice, this is the way that I've assimilated the information from my research into this subject. And by the way, in this video, I'm assuming that the audience is familiar with land patents already, that you've already researched land patents somewhere in the last 7 or 10 years. And this is a revisit of the land patent and the land patent process to perfect a claim as an assign on an original land patent under common law as a superior claim on real estate, right? Or real property or land. That's probably the best way to say it. But that is what the subject of the video is about, and I hope you get something out of this. So I prefaced it that way because if you have not really heard of a land patent and you haven't heard of it in the terms of people making a claim as an assign on an original land patent in the form of property acquisition or in the form of doing it today to demonstrate ownership of property, you got to maybe go get some foundational or some basic research on that, because this is a little bit assuming that you already know that. I just want to clarify some things because I thought I understood it, but I went into a little bit more research, and now based on what I understand, I've dissected and put together what I think is a more thorough procedure than everything I've read about that has been out there prior to this. So, foremost, piggybacking off of what other research sites already tell you, that the land patents are the titles that the United States gave to the original landowners. And I'm saying original landowners under the United States system. As we see right here, this says a patent is the highest evidence of title and is conclusive as against the government and all claiming under junior patents or titles. So junior patents or titles would be warranty deed, grant deed, quitclaim deed, mortgage deed. Now I'm not saying that, for example, mortgage deed could be superior to your claim under a land patent if, as an owner, you entered into a mortgage contract, because the contract is the law too. You see what I'm saying? But generally speaking, so you can know this as you formulate and frame your strategy for whatever it is you're doing. In our case, acquisitions on vacant commercial property. But so that you know with your strategy, the land patent is a claim against the government, and it would be a superior claim in the possession of an owner. So this is why you want to make a claim as an assign under that original land patent, because it's not the same as being the grantee under a mortgage instrument, or under a warranty deed or a grant deed. It's a different type of rights that's conveyed, and tenancy is conveyed. There's a reason why they no longer reference or even make the assignment from the original land patent when they're doing these transfers in the present commercial system, how they do real estate. You're being robbed of your rights somewhere. And I'm not even saying that. I will say that making a claim as an assign under a land patent, that I do think that is what you should be doing. It continues the chain of title on the ownership side, and then you have the ownership, and then you have the tenure. And it seems like they're dealing with the tenure when you're dealing with the grant deeds, the quitclaim deeds, security deeds, and mortgage deeds. This is how the property is being used to produce upon and different things of the such. But it's a different type of rights that gets transferred. So we're reaching higher, right? We're reaching higher by making a claim as an assigned under the original patent deed. What is an assign? An assign, from the definitions I looked at, anyone in possession of the property, especially, and anyone with the quitclaim deed or some other form of title may be eligible to be an assign. But you just have to look at this. No one's going to do this for you. People are divesting and taking rights from you. Let's real quick, I want to look up the definition of an assign. So basically an assign, when you see that in a deed, another term for assignee, right? That's all it is. When there's a conveyance or a transfer of the deed or of rights from any type of action, a transfer of rights, there's an assigner and an assignee. The one who receives the assignment, that makes one an assign. So we're claiming an interest as an assign in the rights. And later on we'll talk about the writ of waste, right? The non-acceptance of deed, the actual procedure that makes you a grantee and continues the chain of title on the public record. But actually, first let's talk about how you get a land patent. The first thing you do is you go to the Bureau of Land Management, which I did. And when you get to the Bureau of Land Management, let me go to their main website. Well, I mean, you can figure this out. When you go to their main website, you go under Services, and then you go under Records. And then when you get to Records, you will get here, and you can click Search Documents. Now, I don't know how to do this, so I can't really take you any further, right? If you want us to do this as a service, though, somebody on our team does this. So if you want us to do your whole land patent, prepare your claim, publish it, and do all of that, we can do that for you. Get in contact with me, and I'll let you know how that works. Or if you see the fee schedule, it's on the fee schedule. So I have somebody that can research this, and maybe you know somebody that can research this. Some of you guys can figure it out. But basically, you'll put your info in here, your state. You'll put the name if you knew who the original patentee was, but you'll put the township, the range, the meridian, the section, all that, and then you click Search Patents. And you will actually find the original land patent. It'll be an image of it, so you can read it and everything. Once you have that, you have the document information that you need, write it down, save it, or whatever. And then you can contact the BLM. I just so happen to be on, I think, the federal site. There's a BLM, Bureau of Land Management, on all your local states, so you can find the local office. Email them, call them on the phone, let them know that you have a original land record and you want a certified copy of it. It'll probably cost you all of $3, and it will get that to you. Islam. So now I want to show you real quick what a land patent looks like. Remember, you can look this up yourself. I'm going to try to breeze through this expeditiously. First, I wanted to touch on, I skimmed over it earlier, but an assign. Basically, every time rights or titles is transferred, there's an assignment. The assignee, the one who receives the assignment, may be referred to as the assign. So I mentioned that to say, from my research, it doesn't necessarily mean that you had to get a direct conveyance from the last so-called owner under the tenancy system of the United States. You didn't have to get a conveyance directly from him to become an assign, right? When we're talking about the chain of title, the basis upon which you're making a claim as an assign. The basis upon which we're making a claim as an assign is the land rights that was acquired by the United States out of some treaty, per se. And again, the thing that I want you to pay attention And our claim of an assign under the original land patent is when we actually get to that part, I'm dealing with three specific things that I'm going to point out in this land patent. One of them you won't see in the land patent because it deals with the treaty that preceded the land patent system to which the United States acquired the land. But based off of a treaty and the Congress of the United States, that relationships is, contracts arising out of that relationships are subject to the Supreme Court. So what I'm trying to do is make sure that my claim of title, which in itself is a deed, that's my claim on the land patent, that's a deed. I want to make sure that anyone who challenges that has to be able to, that they only can take that into the Supreme Court, right? That there is no lower court that's competent, and at best maybe they can take it to a federal court, but they can't really challenge this claim in a state court or county court, which is where most of your real estate controversies is going to take place. That's the idea behind how this claim is structured. So all land patents will give you that information. This is the government's grant of title under its system to the settler, the land settler, and it's a superior claim of that tenant against the government, right? So we want to claim those rights and other rights superior to them. So the things you notice about this is each land patent is going to reference, they're going to cite the act of Congress that that gave the authority for this grant. You want to vest title in your claim, as we'll see, from this instrument, because again, that's a public act of Congress. Once again, this keeps your claim on a higher level. So the act of Congress of May 20th, 1862, but this is going to change. It may be 1870 something, 1890 something, it just depends. It's going to have the original patentee, then it's going to go through the legal description, and at the bottom it's always going to be signed by an executive officer. That's another level of the government, right? So this is directly a relationship between the people, the patentee, the executive branch of government, and the Congress, where they have put forth the public act. So the other thing that's at the core of making a claim as an assign under an original land patent is this part right here, where it will always say, "Know ye that there is therefore granted by the United States unto said claimant," remember they're a claimant, you're a claimant, "the tract of land above described," it's a superior claim now, "to have and to hold the said tract of land with appurtenances thereof unto the said claimant and to their heirs and assigns of said claimant forever." Right? So this is how you're trying to, so they gave that superior title away forever. And even under the Constitution of the United States, the federal government can't own land, which is kind of like a private right of the people. But when you get further into what they actually granted, and I don't want you to dismiss this and make you think that, well, maybe a claim of title is as an assign under land patent isn't a superior claim. Maybe it isn't, but it's superior to warranty deeds and grant deeds and the other things that you're dealing with. So therefore, the point that I was going to make is when you go into a further specific definition of what to have and to hold means, it's going to demonstrate that the grantee receiving this patent was receiving land under a tenancy agreement, whereas the land he received, he's holding it under some type of tenure, and there's really a lord that owns the land. And I didn't get to jump into the research of the lord, but that may possibly signify the lord himself is a trustee for owner. I don't know. But this is where the title begin to be divested from the people in the first conveyance under the supreme title known as what they call the grant deed. But we're making a claim as an assigned under this grant deed, but we're also claiming rights in the land as acquired under the original treaties. This is how we're structuring our common law claim, and we're publishing it in a newspaper for 4 weeks to perfect the claim in common law or at common law. So anyway, this is what the land patent looks like. You see it here. Let's go back to my notes here. This is where you can see, if you look in the Black's Law Dictionary, under the definition, Black's Law 4th Dictionary, if you look under the definition of to, you won't find it under the definition of to have and hold. But if you look under the definition of to, it'll tell you under the definition of to have and hold, strictly speaking. However, the words to have denote the estate to be taken. The words to have denote the estate to be taken, while the words to hold signify that it is to be held of some superior lord by the way of tenure, right? The former cause is called the habendum, the latter is the tenendum. So the United States is doing a tenure system, right? And because they divested themselves of the superior deed to the people, they stopped giving the grant titles. I'm not saying that that's why they did it. I don't know. But today, you're getting grant deeds and warranty deeds, and you're being shorted because it doesn't convey the same type of rights. So somebody like yourself or myself, we're doing this research so that we can reconnect with this with the proper chain of title. Anyway, enough being said about that. Let's get into what the actual claim looks like. Let me see if there's anything I'm forgetting. No, so let's just, I'm going to read over my claim here, and you can listen to it. I like to do everything in trust. So this is me and another Moorish American brother. We're operating through the MDAO Trust, which is a common law trust on record. So we're making this claim. Now, also I want to mention real quick, goes without saying, the land patent covers a vast amount of acreage in most cases. So when you're perfecting a claim, I believe it only makes sense to redefine or give a legal description that defines your particular partition or section of land that you are claiming specific rights to out of the entire patent. So you're still in a sign, over that specific part. But I mention that because if you put your claim out there and you don't properly define the specific part of land, then you're claiming title over the vast amount of whatever estate is claimed under that patent title. So let me read through this and understand there may be a better way to do this. And I invite you, especially Moorish Americans, because I know y'all are watching this, you may see a superior way to set this up and to do this. Contact and reach out, or even if you're not a Moorish American, because if it's sound and it can make this process stronger, I'm going to go revise the notes that go along with this, right? So let's read it. This is our claim that's going to be published in the newspaper for 4 weeks. We, Hill Bay Andre, and Moore Il Sylvester, trustees for the MDAO Trust, being duly sworn under oath, declare and state that we are the assigns of allodial right entitled to lands acquired by the United States under the Treaty of Guadalupe Hidalgo, securing the rights upon which the land was acquired, as described in the United States of America Certificate Number 232 to S. Gaines, executed the 27th day of December 1876 at the city of Washington, D.C. by President Ulysses S. Grant, vesting title from an act of Congress entitled An Act to Further Provisions for the Sale of the Public Lands for the Southwest Quarter of the etc., etc. So now I'm going into the blue part that you see here is the legal description or the property or the land description from the grant patent. The green part here is the property description that I probably would have got from the warranty deed or doing further research into the real estate records, which is the specific area out of the grant for which I am claiming the rights as the assigned, right? So then the claim finishes. Any party claiming an adverse interest to these claims for specific land shall, within 30 days of the first publication, present their verified claim or rebuttal on the record of this matter in writing to the MDOW Trust by mailing to Sue Jane, care of MDOW Trust 123, Notary Public's address, including adverse claimant's office and title. So what I'm suggesting here is, if you have a notary that you can work with, you use that notary's address where you direct people to make the responses if they want to challenge your publication, your claim. So then after 4 weeks, you go back to your notary, and I suspect in the majority, maybe not all, but in the majority of cases, especially when you're dealing with the acquisition of abandoned commercial property or even real estate, that their notary will not have received a reply. So that perfects your claim, which you can now attach to your certified record if you've got the copy of the certified record. So this perfected claim, after it's published, the newspaper, if they're used to doing legal publications, which that's the only newspaper you should deal with, they will provide you with a certificate that has been published for 4 weeks, which is immediately able to be authenticated by the Secretary of State or the Department of State of the United States if you want to do all of that to your deed, because these two documents collectively make your deed. Now, as I was saying before, I personally would not record those in the county unless I was doing it with the intention that I wanted no further claims being made, at least in no time soon during my lifetime or whatever, on this land, and I didn't want to use it as collateral. Because if you want to create a circumstance where you can use the property as collateral for commercial loan, or even for an equity line of credit or something, for the most part, the commercial system is not going to deal with you if they see that superior claim under or claim of a land patent in the county record. Now, the first question is, will the county let you record it? Some are going to fight you on that problem, and some are not. The second question is, do you want to record it? How do you intend to use your claim? Because remember, the claim has already been perfected with the publication under common law. You might find in some counties they pick up on the publication and they do some type of recording irregardless, you know. I've heard that there's private recordings and there's public recordings that may show up on the record and they may not show on the record. But what I think is most important is, since you have those original records, you file your UCC financing statement, right? And you keep those original records secure. If you ever have to produce those evidences, you know, like on a public side of a court record, you can use your UCC filing. If you really had to protect your claim, you can send it to a constitutional officer, judge, or whoever's the presiding officer in the controversy. You can send them that perfected claim, which is perfected under common law, special deposit, in camera, you know, appointing him, basically appointing him to settle the matter, whatever it is. You have to structure it based off of what it is, and then that goes into the deeper research. If you find yourself in that type of situation, I encourage you to do the further research under administrative procedure in dealing with public officials, because everything that you're doing under common law comes back to your right to own land and to pursue ownership of land and to be secure in its ownership. You know, so it's a right. So you can appoint them if you're operating lawfully. You know, they have a constitutional oath and they have a bond. You can, as long as you're operating on key, you can make them enforce this. This is why you went through the process. You know, at least this is the way that I see it from our research. I hope that makes sense. Let me show you one more thing real quick before I close this out. This is an example of a publication that I've done for a copyright. I haven't done the one for the land patent yet. We'll be doing that probably this week or so. But I mean, it's nothing, they don't challenge you doing a publication in the paper. So we still do provide the services. And of course, if you're a member of thttrust.org, you have access to the templates. You can do it yourself. But notice this is set up like a court case. This particular publication is, was a copyright. So they say proof of publication. The case is a copyright. They line it up, the state, the county, and they lay it all out, and it's signed by a few parties that work for this legal publication, and they are notaries. So with their seals and their signatures, you can actually authenticate this as evidence of the publication in the state. So remember, if there was no challenge at the notary, if you find the need, you can do an affidavit of non-response and sign that affidavit in front of the same notary whose address you use to receive any responses, because a notary in that way doesn't have to get involved in your process, but at the same time, a notary won't swear to a material fact that they know is false. So indirectly, the notary is acknowledging the fact that there has been no response to your process. If there is a response, you have to respond to whoever responded on the record. You have to respond until that response is shut down. Now, before we got to this phase, which I didn't discuss in this video, we already have mechanics lien, and we already have other security interests recorded in this property, because this property, the property that we're working on in this particular one, this is a real claim that you're looking at. This property was it was being turned into a waste, particularly. So we are not worried about somebody responding to our claim of ownership, because then if they're saying that no, you're not, we're the owner, they have some superior claim, then we have some business to settle with them, right? If they want to send us on our merry way, that's fine, but we have to be paid, right? This is how you got to set things up. So you do that, and usually there's not going to be people arbitrarily interfering.